मर्जर मर्जर में इतना टाइम नहीं लगना चाहिए सर, ऐसा राइट One question was whether secured creditor includes a guaranteed amount as well. Somebody stood a guarantee. There is no security as such, but there is a guarantee. Does it count as secured creditor? Answer will be no. The secured creditor includes only those cases where there is an asset which is available to the secured creditor. Assets may be tangible as well as intangible. In RBI parlance, it's only tangible assets which are counted as assets. But in corporate law parlance, any asset, including intangible assets, for example, even a receivable is an intangible asset, but it's still counted as security. Another question, a very important question, I think is relevant from all practitioners' perspective. I think something on which all of you can also contribute, which is that all this field, liquidation of companies, appearance before NCLTs, handling, resolution, etc., in the past has all been the domain of lawyers. To what extent do we expect company secretaries to make inroads into the world which was so long a preserve of the advocates? So I think in answer, this is what I would say. I would say 2002 when the NCLT came into existence for the first time, lawyers were the first ones to appeal against it. Madras Bar Association went to court, first Madras High Court, then Supreme Court obtained a stay, and they were able to manage the stay for as long as 12 years approximately. Companies Act 2013 came, they once again went into another litigation, which was over in 2015. Why were the lawyers so unhappy? Were they unhappy with NCLT? They were unhappy because somebody else is now getting a right to appeal. Now, अब ये देखिए, let's say operation mismanagement is a domain before CLB or NCLT now, and in this domain, company secretaries were entitled to appear ever since 1990s. Whenever the CLB 1991 probably. So it's been 25 years that company secretaries were entitled to appear and handle cases of operation mismanagement. So the question that we all need to ask is, how many of us actually do that? Was it a question of entitlement that we were waiting for all this while? 25 years, how many cases of operation company secretaries handle all by themselves? They'll probably handle it from the background. Like Pawanji was saying, they'll probably do the backroom work, but when it comes to appearance, it's mostly still advocates, even though before CLB, a company secretary or a chartered accountant or a cost accountant is well entitled to appear. I've not seen any CAs at all. I don't know whether Northern region benches there a difference, but CAs, I rarely see as appearing before the CLB. Company secretaries, some of them do, but most of them don't. Mostly it's occupied still by lawyers. So eventually it's not a question of whether you are entitled to appear or not. The question is whether you are capable of appearing or not. Capability is more important. I mean, the moot point is, are we capable of handling? If we have capability, whether we are entitled or not does not actually matter much. I mean, if capabilities are there, you would probably might be giving meaningful advice even from the background. But if it's a question of competency, which is where we need to actually, ramp up our capabilities, the entitlement as such is by itself not a major roadblock. So, in answer to the question, to what extent would we actually be able to give a challenge to our other fellow professionals? I think it's all a question of competence. Certain areas we are much better. There's no doubt that when it comes to MGT 14, nothing can beat us. But when it comes to listing out compliances step by step, company secretaries do an excellent job. But when it comes to things like preparing a resolution plan, preparing a turnaround plan, financial restructuring, do we have competence? Of course, all of us, I don't even expect everybody to be competent in everything, but I guess there will be specializations, pockets of specialization that would emerge. There will be people who are quite good in appearing for NCLT, there will be people who are good in handling resolutions, there will be people who are good in handling liquidations, for example. So I think people will probably develop their own niche areas of competence, and whether you are a lawyer or cost accountant or chartered accountant or company secretary would probably matter less than what is your specific area of competence. That's my view. I don't know what, would you share the same view or have a difference of view? These were questions I got during the lunch break, but can we just proceed? I hope all of you had lunch. It was a crowded place outside, almost like being the last participant in the waterfall. But I'm assuming that all of you could get something to grab. So I'll give a quick view of the personal resolution first, personal insolvency, and then move to details of each of these. Personal insolvency, as Pawanji mentioned rightly enough, that personal insolvency, that is non-corporate persons, the resolution of insolvency as well as bankruptcy will both be handled by DRTs. Now assume a case where we have company, let's say Kingfisher, Mr. Malla is the guarantor. So I am going for, let's say, insolvency of Kingfisher, and I want to involve Mr. Malla also. So does that mean I will go to NCLT and DRT both simultaneously? Against the company before NCLT, against Mr. Malla before DRT, is that so?
No.
This would actually be a debacle. To keep kind of, forum shopping, first go to NCLT, then go to DRT and keep switching places, because these two are part of the same game. They are not two different games. It's nothing but two elements of the same process. So there the court has a clear provision that if you are going for insolvency of an individual who is a guarantor to a corporate person, in that case you will file the case before NCLT only. So NCLT is the domain for corporate persons and for guarantors to corporate persons. For example, individuals who are guarantors to corporate persons, that also comes before NCLT. A point I mentioned some time back, hope all of you recall that the code is limited in its scope to entities excluding those which are financial service providers. Providers of financial services, that includes SEBI registered entities, RBI registered entities, they will be excluded from the code. So you cannot file for insolvency of a merchant banker or stockbroker or an NBFC or a bank under the code. You will have to go under a separate law, which we are told is due to be introduced soon. I don't think there will be much of difficulty because the model is already there. They'll probably model it on the same pattern as this code. Maybe probably introduced in one of the forthcoming sessions of Parliament. Non-corporate persons. So non-corporate persons will include what all? Individuals. What about partnership firms? Also? LLPs? No. LLPs come under NCLT, corporate persons. When it comes to partnership firms, once again a gap left by the law is what about those partnership firms which have companies as partners? If we have a partnership firm consisting of companies as partners, then where do we go? Because the law says for liquidation or insolvency of a partnership firm, we need to go to DRT. But insolvency of partnership firm also includes insolvency of partners. Because if the firm becomes insolvent, by definition it means the partner is also insolvent. I hope you understand, partners have unlimited liability. To the extent the firm has a liability, its partner's personal liability also. So every partner is supposed to contribute to an unlimited extent to the liability of the firm. If a firm is insolvent, that would mean each partner is, and the partners may include companies as well. This question is left unanswered by the court. Our answer is, to the extent there is a corporate partner, you will still have to go to the NCLT because you can't expect DRTs to resolve. So if it's a partnership firm consisting of two companies only, in that case NCLT is the forum. If a partnership consists of an individual and a company, in that case to the extent of individual, go to DRT, to the extent of a company, go to NCLT. That's a gap left by law, but that's the only possible answer I can think of.
So in partnership, the Section 8 company can become the member.
Correct.
So if in partnership, Section 8 companies are member, then they will.
It's other way around actually. In a Section 8 company, a firm can become a member. A company can be partner of any partnership firm. There's no bar on a company becoming a partner in a firm. Are you getting me? A company can be. There are any number of JVs. No? Most of the roads are built by joint ventures, which are joint ventures of two companies. Most of the roads, I think most of the BOT projects have companies as partners. Joint ventures between companies and individuals are fairly common. But what you're actually saying basically is that in a Section 8 company, there's an exception that a firm can become a member. Whereas normally speaking, a firm cannot be a member of the company. Right? So that still, I think the point still remains. The point as I mentioned still remains. Right? So let's move on. So if if there's an insolvency of individuals, what's the process? In case of, before that I'll quickly mention the voluntary liquidation process also. Voluntary liquidation, like I mentioned earlier, we've actually mixed up creditors voluntary winding up and members voluntary winding up into a single process. Therefore, every voluntary winding up requires both members resolution as also creditors resolution. Members must agree by special resolution, directors must give a declaration of solvency, and at the same time we will also need to take creditor sanction. Creditor sanction required for voluntary winding up. For normal winding up, creditor sanction required was 75%. But for voluntary winding up, the sanction required is only 2/3, that is 67%. So creditors must with 2/3 majority agree to the voluntary winding up. Assuming members have agreed, creditors have declined, in that case what option do we have? We cannot take it under voluntary winding up, therefore we'll still have to fall in line with compulsory winding up under section 433 of earlier act or 271 of this act, because members may resolve to wind up a company and that can still go ahead as a compulsory winding up before a court. Voluntary winding up under the code, that is bankruptcy code, and compulsory winding up before the Companies Act. What's the difference? NCLT is the forum in both the cases. But that compulsory winding up process, the liquidator is the liquidator as under the Companies Act, which may include, for example, official liquidator or private liquidator as appointed by the NCLT. In case of voluntary winding up, the appointment of liquidator is done by the company itself. Members by special resolution appoint a liquidator. So liquidator is the member's own choice. Whereas in case of compulsory winding up, it's imposed upon the company. Hope you can actually realize that in actual process of liquidation, your choice of who the liquidator is very important, because you would like to choose a person who is convenient for you. Who can handle your liquidation job efficiently and based on your objectives. So, voluntary winding up process, the company must be solvent, directors must give a declaration of solvency. Once the liquidator is appointed, as usual, board of directors, they cease to be holding any power. Liquidator starts running the business of the company. Liquidator realizes all assets, pays off money to the members, or first the creditors, then the members. And as in case of insolvency or bankruptcy, here also liquidator has a power to use the avoidance, the 4 powers I said about avoidance of transactions. Liquidator may use those avoidance powers here also. The company is solvent here, so insolvency principles are not applicable. So question of priority of distribution does not arise because everybody is likely to be paid. So we don't actually have a deficit here, so no question of priorities. Non-corporate persons. So first, there is a process called fresh start order. Fresh start order or fresh start process. Fresh start is almost like debt relief. जैसे फार्मर्स का लोन वेवर होता था, कभी कभी पॉलिटिशियंस आके फार्मर्स का लोन वेव करते थे, वैसा ही प्रोसेस है. This is of course meant for a very small amount of debt and for persons having very small income. वो कैसे इस लो में आएंगे, कैसे प्रोफेशनल की फी भी कर पाएंगे, मेरे को समझ में नहीं आता है. Because लो बोलता है उनकी एनुअल इनकम शुड बी 60,000 रुपीज पर annum, मंथली इनकम 5,000 रुपए पर मंथ. 5,000 रुपए पर मंथ कमाने वाले आदमी को कोई हेल्प करने के लिए कैसे प्रोफेशनल आएगा, कौन उसकी फीस देगा? I don't know. I don't have answers to any of these questions. But the fresh start order is a straight debt relief. यहाँ there is no question of repayment plan. A person incurs a small debt, is a small individual with very meager resources. He straight applies to the adjudicating body, which is DRT here, and if the DRT is convinced that the case falls under fresh start order, there will be complete loan waiver. Loan का पूरा waive हो जाएगा. He gets a complete fresh start order, complete discharge without having to pay anybody. Having got a fresh start order in a, let's say, particular year, can he once again become insolvent? एक बार debt relief किया, can he once again become insolvent and say come for debt relief next time also? Presumably, law gives him only a 12-month period. That would mean for next 12 months, he can't come for a debt relief. Which means every year, if he so plans his affairs, he can come for a fresh start almost every year. But the provisions are very impractical. Why were they at all drawn up? I don't know. Once again, because we're emulating the UK law. UK has a process called debt relief order. We, I think, use the same process and put a provision for fresh start order. This will be very impractical. I don't think we'll as professionals will have much to do with this, but I think microfinance companies may need to take notice. Mostly MFIs, MFI borrowers will possibly fall under the fresh start provision also. No, there is a carve out for what is called excluded debt. That would mean for what is excluded debt, excluded debt will not be eligible for a fresh start order. Whether MFI loans will be excluded debt or not, I don't know. Most likely not. To best of my understanding, excluded debt will be credit card receivables and educational loans. Educational loans will most likely be excluded because somebody takes a student loan and then goes for a fresh, the complete debt relief. It would be a debacle for those who lend for education. So for educational loans, I don't think there'll be any, they'll not be covered by the fresh start order. MFI debt, whether it will be covered or not, to my mind, probably not, because I don't think intent of law could be to exempt MFIs from the fresh start order applicability. So you see the condition of eligibility for fresh start order, and you will see mostly MFI customers will fall under that process. So the MFIs may have to, keep in mind the possibility that some of the customers can go for a fresh start order. Mostly, however, the borrowers will not qualify for fresh start order and therefore will go for the insolvency process. So like in case of companies, here also two phases, insolvency phase and bankruptcy phase. Eventually, of course, we go for a discharge. Unlike in case of companies, where there are only two moratoriums, I hope you recall, one moratorium was during preparation of resolution plan, second was during liquidation. In case of individuals, there are four moratoriums. First moratorium is from date of filing of the application till the date of admission of application. From the date of filing till admission of insolvency application. From filing date to admission date, that's one moratorium. Second moratorium is from admission date till the end of the resolution process. Unlike in case of companies where a 180-day maximum time limit is late, in case of individuals there is no outer time limit. There are time limits for each step. Looking at each of the steps, it seems like 90 days, 210 days, 120 days should be the outer limit. But there is no aggregate time limit from the date of admission till the completion of the resolution process, though each step by itself has timelines. So that's the second moratorium, which is after till the admission of resolution plan. And once again, as in case of companies, once the resolution plan is admitted and let's say order is passed, creditors will obviously act as per resolution plan. Third moratorium is on date of filing of bankruptcy application. From date of filing till the date of admission of bankruptcy application. And lastly, the moratorium is from date of admission of bankruptcy application till the date of completion of the bankruptcy process. Date of completion of bankruptcy process would mean till the date all the assets of the bankrupt have been disposed of and the creditors have been paid from that. So during the first two moratoriums, that is from initial filing of application till admission and from admission till completion of resolution process, enforcement action by secured creditors will get stayed. That would mean secured creditors will not be entitled to take enforcement action, whether it is SARFAESI Act or any other act. Even in case of home loans, housing loans also, enforcement action will get stayed from the date of filing till the date of completion of the resolution process. However, during the third and fourth moratorium, that is during bankruptcy process, a secured creditor, if it's decided to enforce security interest and not give it up, he will still be entitled to enforce security interest. I hope I'm coming clear. So enforcement actions on the part of a secured creditor will be stayed during the first two moratoriums. There is a very strange process of law when it comes to insolvency of individuals. And in our country, given the fact that lawyers and professionals can use gaps in law with the very, very imaginative uses, so I think this will be exploited to quite a hilt, and this will actually become a major challenge in meeting the timelines. The law comes with a stringent timelines. For almost everything there is a timeline, 7 days, 10 days, 12 days, etc. When I said this to some senior advocates that law has put very strict timelines, for example, the timeline for a timeline for NCLT to decide any matter. Currently NCLT take how much timeline? Like let's say operation mismanagement. सर ने सुना ही नहीं, बोल रहे 10 साल, बिकॉज सर का लंबा एक्सपीरियंस है, बता रहे 10 साल भी मैटर रिजोल्व हो जाए। एक्चुअली मैटर रिजोल्व नहीं होता है, होता क्या है कि पार्टीज थक हार के सेटल कर लेते हैं या फिर भूल जाते हैं, बहुत पैसा खर्चा कर दिया अब। नाउ लॉ सेज 90 days and for reasons to be recorded by the president of NCLT another 45 days. I said this to a senior counsel के साथ, देखिए now earlier there was no timeline, now the law says 90 days NCLT has to decide with extended period of 45 days, that too for reasons to be recorded by president of NCLT, president, so the chairman of NCLT. So this the lawyer said कि DRT में also there have been timelines since the DRT law was framed, timelines were there, कभी timeline हुआ has been.
कंज्यूमर प्रोटेक्शन में भी तो है कि नॉर्मल केस ही 4-5 साल चलता है,
right? So timelines were there, but अच्छा जैसे आपके लिए timeline है, for example you don't file MGT 14 in 30 days, there is an additional fee to be paid, 270 दिन के बाद वो कंपाउंडिंग में जाना पड़ेगा। NCLT के लिए वैसा है, member does not take decision in 45 days, is he liable to any punishment? But I'm surprised, why not? After all, the member of NCLT is not above the law, is not anything other than a part of us. If there's a timeline for citizens, subjects of law, why can't there be a timeline for the regulators, and there's a penal action for the regulators as well? Somebody has to raise this voice. It's extreme state of, I would say, inconsistency where we don't do something in time and there's an implication of that. The lawmakers or regulators don't act in time, there's no implication whatsoever.
Technically, High Court से direction देते हैं ऐसे CMD को, you have to pass this order within 6 months.
वो भी नहीं होता है,
वो भी नहीं होता है।
उसमें contempt कर सकते, probably somebody should take it up. Somebody should take this up. There's nothing but a contempt of court.
सर मगर दोबारा उसी फोरम के पास आपको अपने उसके केस के लिए जाना है तो वो आपके लिए कॉन्ट्रैक्ट हो जाएगा।
Yeah, it's practical difficulty, but this is, yeah, you as an individual may not like to raise a voice because then you'll be discriminated against. But as collectively, I'm not sure somebody, किसी ने right to information किसी ने तो plead किया होगा ना? RTI is basically what? It's a boon to democracy, because how can you hide state secrets and say we will not let it out in open because it's state secret? What could be secret between the country and its people? I don't know. After all, the government is supposed to serve the people, so what could be secret between the government and the people? And likewise, what could be so great with NCLT members that they are above the society and there is no penal action for them if they don't fail to meet the timelines?
This is only mindset, this is nothing. You remember Negotiable Instrument Act, the cases used to go to 5 years.
Correct.
The Supreme Court put something, everything is settling. I discussed the matter with the chairman of NCLT, president of NCLT. You know what reply he gave to me? Mr. Tyagi, look, this is the case on my table, 2000 pages. If I order for reply, it will be another 1000 pages. So it's a question of mindset between the judiciary and our
Fellow professionals.
advocates.
Because fellow professionals, we all thrive on these delays.
Yes.
I think we all thrive because the more adjournment we take, there's a more, consequential benefits
Sir,
to
why
us.
10 years? जो defendant था कि 4-5 साल reply file नहीं करता।
I think the common consensus is as long as you keep feeding your lawyers, you can drag the litigation. When you are tired of spending money, you think enough is enough, let's now stop. That's when we either settle or we just forget about the case. But no case ever reaches resolution. Anyway, so there are timelines for NCTs, there are timelines for the law also. And I was saying that there's a very strange process where professionals can actually misuse it for extending, prolonging or elongating the process. ये process क्या है? When you file resolution application, in case of companies, the applicant will have to name a resolution professional. For example, creditor files it, creditor will name the resolution professional. Company files it, company names the resolution professional. That's what we call is an interim resolution professional. Once we file and once an IRP is nominated, then the IRP's first job is to call a meeting of creditors and get his appointment regularized. That's the process. In case of individuals, probably looking at that lots of individuals may not have, approach with the liquidator. So law says an individual can file a self-protection application. He can file application himself that I want protection under bankruptcy code, and he may not name the resolution professional. So he might file it without the name. If he files it without the name, what's the process? Then the DRT will make a reference to IBBI, the board, to appoint a resolution professional. So now the matter, DRT sends a reference to IBBI, which is the board, Insolvency Bankruptcy Board of India. The timeline for that is 7 days. Within 7 days, DRT will refer the matter to IBBI. IBBI then within 10 days will refer the name of the professional whose appointment is done. Now think of the scope of litigation for this. So intently I'll file application without the name. I expect NCLT will act, DRT will act within 7 days. Most likely DRT will not act in 7 days. Because I can thrive on this. DRTs are, lots of vacant positions are there. DRT members may not be there on time. So instead of 7 days, probably might take action in 30 days time. So do you understand the moratorium starts from date of filing itself. Moratorium is not from date of acceptance. Moratorium is from the date of filing. So I file it purposely without a name. Now let's say supposing the DRT acts in time and they send it within 7 days time. IBBI will then appoint a person. Does IBBI consult the person that I am going to appoint you? Obviously they will not. So now IBBI names, let's say Vinod Kothari. Vinod Kothari in turn comes and says, I am overburdened, I will not be able to take the reference. Then the DRT will once again make a reference. Matter goes back to IBBI. IBBI once again names a person. This time let's say IBBI named Mr. Tyagi. I am the individual in question, I will say I don't like Mr. Tyagi's approach, so I contest that. So I say I am not agreeable to this, so I take it to appeal. Because this is also an order. Appointing Mr. Tyagi as the professional is itself an order. And this is an appealable order, so I can go to DR80 in appeal. DR80 is supposed to resolve the matter. DR80 will most likely do what? Will set it aside and send it back. Once the process comes back to DR80, the whole process starts all over again. So it becomes a loop. I can, as many times I can repeat the loop, I can actually drag the process. So the point I'm making is that the entire process is liable to such an abuse, and the moratorium starts from the date of filing itself. So purposely people could file even frivolous applications and drag them for a long time and thereby gain a moratorium. So that's the first stage. Second moratorium starts on date of acceptance. Thereafter, resolution plan will be prepared by the creditors. Once again, 3/4 in value will sanction the resolution plan. Resolution plan mostly क्या बोलता होगा? Resolution plan in case of companies will be almost like a CDR or SDR kind of a structure. It will basically say, well, there's too much of debt in the company, there's too little equity, this much debt is not sustainable, let a part of the debt be converted into equity, let remaining debt there will be more time given to payment, etc. Some non-core assets, some non-core businesses must be disposed of. Let the company move from owned premises to rented premises, sell off the assets, realize money, pay off creditors, etc. So resolution plan will depend on, somebody's expertise in resolving corporate default cases so as to lessen the debt servicing burden on the company. In case of individuals, once again looking mostly at international experience, resolution plans typically depend on the nature of income of the individual. The individual is not out of job, is still earning money. So if he is earning money, well, every month he must be able to save something and he must direct at least a part of his monthly earnings to pay off the creditors. So typical repayment plan will be that he will use 50% of his income for his expenses. Remaining 50% will go into an escrow account from where it will be used to pay off the creditors. Normally it would be 3 to 5 to 6, 7 years time within which the creditors will get paid off from out of his regular incomes. If the creditors approve this plan, the plan gets implemented. Implementation of plan will also be supervised by the resolution professional. So the insolvency professional is not merely preparing the plan or having the plan prepared, he is also supervising the implementation of the plan as well. That's an important difference. Next, supposing the resolution plan is either not prepared or creditors reject it, or the plan is prepared but is not adhered to, in either case there will be a filing for bankruptcy. Bankruptcy filing is not automatic. So somebody has to file for bankruptcy once again. Same process here. You can name a liquidator, that is bankruptcy trustee, or you may not name it. If you don't name it, then the DRT will make a reference to IBBI for appointment of a bankruptcy trustee. This time we call it trustee here. In case of companies we call it liquidator. In case of individuals it's not obviously liquidation, so we call it bankruptcy trustee. So bankruptcy trustee will take over once the bankruptcy order is passed. That's called commencement of bankruptcy happens when the bankruptcy petition is admitted. And soonest thereafter, the DRT will appoint a bankruptcy trustee. So individual का bankruptcy process क्या है? All the assets of the individual, excepting excluded asset, exempted assets. Some assets are exempted from the bankruptcy process. For example, what? Guess what? What assets could be exempted from bankruptcy process in case of individuals? Like, for example, to draw a parallel, you can say section 60 of CPC, attachment of assets of an individual. Some assets are not liable to be attached. For example, what all they could be? PPF, public provident fund. PF is, but PPF is not. Wearing apparel, you still need to put on clothes. Domestic utensils, household furniture. Some of these, in case of ladies, the basic jewelry that, so-called, let's say, Sridhan kind of jewelry. So these are what you call exempt, or like in case of artisans, the artisans' tools. Like a carpenter, his tools cannot be attached because he has to still work as a carpenter. So these basic assets are not, they are called excluded or exempted assets. Likewise, in case of individuals also, excluded assets partly are defined by law and partly will be notified by way of rules. One of the exempted assets is a basic dwelling unit. Kingfisher house, no. So don't think that you'll be able to still live in luxury in a Alishan bungalow. But basic dwelling unit, that would mean the individual will not be on the road, will not be thrown without a roof on his head. Some basic dwelling unit of such value and such parameters as may be defined by the rules. So I'm guessing at least a 1 BHK kind of house will be given to the individual to still stay and carry on his life. So that's excluded assets. Other than that, everything else will be, everything else will now become the property of the trustee. Assets automatically get vested in the trustee. When the question of vesting comes, vesting kaise hota hai? Will there be some kind of a conveyance or a transfer or assignment to transfer the assets to a trustee? The vesting is automatic. That is, on passing of the bankruptcy order itself, assets of the individual automatically get vested. कुछ भी करने की जरूरत नहीं है इसके लिए. Public notice तो bankruptcy का होगा ही होगा. In any insolvency का भी होता है, bankruptcy का भी होता है. Insolvency का भी public notice दिया जाएगा, bankruptcy का दो भी जरूरी है. Insolvency का क्यों जरूरी है? Because people who are dealing with the insolvent must be put to notice that you are dealing with insolvent entity now. Bankrupt के किसमें और भी जरूरी है? Means bankrupt is incompetent to contract until he attains a discharge. So public notice is always there though, but when all the assets of the individual automatically vest in the bankruptcy trustee. Trustee will do what? Trustee will start liquidating the assets. The avoidance powers. Recall in case of companies we said several things that the trustee can avoid. There are similar avoidance powers under individual insolvency also. Actually there are wider powers of avoidance of transactions. So trustee may, in order to enhance the value of the estate, so-called liquidation estate, he may avoid certain assets and he may avoid certain transactions and restore the assets which have moved away from the assets of the individual in question. When will the bankruptcy trustee get it? When will he get a release? Bankruptcy trustee will get a release when he has done his job. When is his job done? When he has sold off all the assets and paid off all the creditors. Now in the meantime, the period of 1 year for discharge, I hope you recall, I said after 12 months from date of bankruptcy, the individual will mandatorily get a discharge. Assets may not be disposed of in 1 year time. For example, some assets may take 5 years to dispose of. So whether or not assets have been sold off, the individual will still be discharged after 12 months, but the trustee's job will continue. The trustee will continue to sell off assets and will continue to pay off the creditors. Trustee will get a release only when all the assets have been used to pay off the creditors. Important situation, supposing at the end of the process we find that there are some assets still left, surplus assets. Though as I mentioned earlier that it is unlikely that a surplus asset must remain. Because after all the person was a bankrupt and bankruptcy is a case of deficit. But because of asset values going up etc., sometimes there might be surpluses also. So surplus will go to the individual. Surplus will go back to the individual. There are some very important principles of what happens to interest during the bankruptcy process. Once the bankruptcy order is passed, to the extent of outstanding claims, whether interest continues to accrue or interest stops accruing. Very important question. We'll come back to each of these when we discuss things in detail. Now in terms of priorities, in case of companies we said there is a distinction between financial creditors and operational creditors. In case of individual there is no such distinction. So there is Every creditor is of single class, financial operational creditor there, which means every creditor, based on whether it's secured or unsecured, has the same level of priority. Distribution order is very similar, without any distinction between financial creditors and operational creditors. So this is, I would say, very quick snapshot of the entire process. Do you have any questions before we get into some details? Okay, I'll take you through the process of insolvency. So we're switching back to corporate insolvency, getting into some details, and I'll now make only specific points because you've seen the process overall process at length. I will just make some quick significant points. So first of all, we talked about distinction between financial and operational creditors. Don't want to repeat that. And discuss the insolvency application can be filed either by financial creditor or by operational creditor or by the company itself. And the company might be motivated to file it because in that case the company names the resolution professional. The company obviously gets some advantage because the company names it, though of course the creditors committee may later on dismiss the person and appoint a new person. What all things cannot be done during moratorium? First, moratorium. A moratorium starts on admission of insolvency application. What all things cannot be done during the moratorium? So obviously, can the company sell off assets during that process? No. Sure, the company cannot sell off its assets. Huh? The company cannot, can the company incur fresh debt?
No.
Can the company borrow? I said yes, the company can, because that's the power given to resolution professional now. The resolution, because now the board of directors has ceased to have power. Once the resolution application gets admitted, powers of board of directors cease, and the insolvency resolution professional starts running the company. He starts running the show. So if he thinks that some further debt is required for the purpose of resolution, he may raise debt. So borrowing is possible during resolution. That's what I mentioned is called DIP financing, and this financing gets a super priority, as this is the very first item in the waterfall. So borrowing is possible. Can the company's business be carried on? Answer is yes, because the company is still a going concern. The company will continue to carry its business as it was carrying before. Can shareholders resolution be passed? For example, let's say power to raise further capital. Will it require shareholders resolution? There's nothing in law to stop the powers of shareholders. Powers of board of directors cease. But powers of shareholders as required from point of view of corporate laws, they will still be exercised by shareholders. So if general meeting is to be called, general meeting will still be called. Shareholders' consent is taken, shareholders' consent will still be taken. Sure enough, the powers of liquidator will prevail over the powers of board of directors, but shareholders' powers will still continue to remain in operation. Can a secured creditor enforce security interest during the moratorium? Answer will be no. So surfacey action will be stopped. Now think of this. Let's say the company has taken certain assets on lease. The company has taken certain assets on lease basis. Can the lessor of the assets exercise rights of repossession, claiming the assets are mine? We said a secured creditor will not repo assets. But can a lessor of an asset taken on financial lease basis? For example, the company has taken a car on lease and the company is not paying the rentals. Can the lessor repossess the asset, take it away? Yes, no. So the law says no. Law says even enforcement of rights of lessor under a lease contract will also get stayed during the first moratorium. Now, I'll take it forward. Let's suppose the company is carrying its business in a rented premise. Office let's say is working in a rented premise, and the company is not been paying office rentals. Can the landlord throw the company out? To this also the law seems to say no. During the SICA moratorium, section 22 of SICA, there have been rulings on both sides. Some courts have said the landlord can throw the company, some courts have said the landlord cannot throw the company. There is a confusion. But in the code, it is coming clear that foreclosure of any tenancy or any lease is also staged during the moratorium, so as to allow a complete standstill. The purpose of moratorium is that the company may focus on reviving its business and forget about other worldly worries. It's almost like call it like Adhyatmik Shanti kind of a process for the company. So the company has complete internal peace. It's trying to revive, focus on its revival. During that process, the company does not have any threat of from either a lender or from a lessor of an asset. So that is during the first moratorium. Of course, once the first moratorium ends, secured creditor can jump in action, and of course a lessor can also throw the company out for non-payment of rentals. That's the first moratorium. Let's move. Can the income tax officer enforce a demand? During the first moratorium, can the tax officer slap a demand notice and attach the company's bank account? Once again, no. Can the tax officer complete assessment? Because the law says any proceeding against the company will be stayed. Proceeding includes assessment proceeding also. So, will the moratorium also mean a stay on completion of assessments also? To this, there have been rulings earlier to say that there is no stay on assessment proceeding, because we can't expect the liquidator or resolution professional to carry out assessments. So the law will carry out its process, just that the enforcement of demand will get stayed. Criminal proceedings, section 138 shoot. The company has a check drawn by the company got bounced. Can the directors be sent to jail during the moratorium process? Huh? No, but the check was drawn when he was a director, the check got bounced. So can section 138, can he be prosecuted?
I think criminal proceedings should not be stayed.
There is no stay on criminal proceeding. The proceedings are stayed against the company or the property of the company. Section 138 is for prosecution of the directors. It's a criminal prosecution. So there is no question of staying criminal proceedings against the directors for whatever crimes they've done. Not paying money is not a crime. However, bouncing of a check is a crime. Does it sound logical? You don't pay somebody what you promised to pay. That's not a crime. But the check drawn by you get bounced. That's a crime. Why? Because check is a promise to the world at large. Because check is a mode of payment. By drawing a check, I am making a promise to the world that I have paid. And it's a promise to the world at large because a check is a negotiable instrument. It can change from hand to hand.
No, but so in case of paycheck, it's a promise to the pay only.
Account pay does not mean it's not negotiable. Every negotiable instrument is negotiable. Account pay check only means it will not be encashed on the counter of the bank. You cannot put it in the teller machine and get cash out. You have to deposit in the pay's account. Pay could be changed. It's a different thing that normally speaking there is no endorsement of account pay checks. Most banks don't even understand that account pay checks can also be endorsed. But there is no bar on endorsement. And in any case, drawing of a check is a method of settling a debt. So somebody who is drawing a check is making a promise to the world at large that I have paid the money. And that becomes once the check becomes dead check, it bounces. That would mean you made a criminal promise, a criminal breach of promise to the world at large that you actually paid the money. That's why there is a question of prosecution. Same is the case for payment settlement, electronic remittance instruction. It goes in the same line as section 138 of negotiable instruments. So there is no stay on criminal proceedings. Okay, we talked about the effect of moratorium process. I will continue moving forward and stop only when there is a specific point to make. Maximum time I mentioned 180 days plus 90 days. Implementation of resolution plan. The plan once implemented, once accepted, implemented is binding on the company, that is the debtor, on all employees, members, creditors, guarantors or other stakeholders. So it's applicable on everybody. It becomes a kind of statutory contract. It's a contractual plan, but the effect is that of a statute. So it becomes a statutory contract. We have also mentioned restructuring under Companies Act, section 230 or 391 versus the Companies Act. The basic difference is that there is no concept of classes under the bankruptcy code. So we will, there's also something called fast track process. In case of companies, there's a process called fast track process as well. Fast track process will be applicable for assets of such amount as the central government will notify. So the assets of the company are up to a particular amount which is to be notified by central government. then the insolvency resolution will be done on a fast track basis, which is double the speed. So timeline here will be, instead of 180 days it becomes 90 days. Extension instead of 90 days becomes 45 days. The timelines are exactly halved. That's fast track. Other than that, it's all the same. Now let's move on to liquidation. Very important point in case of liquidation. So liquidation, first of all, can somebody go for liquidation straight away? If money is not paid, like currently what do we do? Money is not paid, we say we'll file winding up application. Under the bankruptcy code, if money is not paid, can a banker go and straight say I want to liquidate the company? Or does it necessarily have to go through resolution?
The winding up cannot be a route for recovery.
So winding up is not...
First stage. Winding up cannot be a first stage for recovery at the first stage. Winding up would be a last resort if company is unable to pay it.
Existing companies, that's not correct. Existing companies, that the company has not paid what is due. But that becomes a presumption that the company is unable to pay. So at the very first, on non-payment itself, we serve a demand notice. The company does not satisfactorily answer the demand notice, then you file a winding up petition. So under the current law, you can file for winding up straight away. Under the bankruptcy code, there is no option to file for liquidation in the first instance. You have to apply for insolvency first. Insolvency fails, then liquidation. Though the control is entirely with creditors, but creditors will have to go first for insolvency, eventually go for bankruptcy. So does it mean the creditors will necessarily have to wait for 6 months before they file for liquidation?
Yes.
Actually not, because in the very first meeting itself, we got sufficient consensus with yourself. Let's say you are holding 75%. In the very first meeting, you can vote out. You can probably say no resolution, nothing doing. We'll file for liquidation straight away. So there's, the process is that you have to file for insolvency resolution first, but you can fast track the process. You can make a decision in the very first meeting itself, or maybe if somebody is, let's say, creditor holding 75% is the petitioner. In the petition itself, he might say that there's no point in calling a meeting with I am the 75% owner. Are you getting me? When we file for insolvency application, if I am the creditor, I might say I am holding 80% of the company's debt, or I am the sole creditor, sole financial creditor, and I am not interested in resolving it. I don't want resolution. So you could probably make a composite application and say my application for insolvency resolution may be treated as my application for bankruptcy as well. Because in any case, I hereby vote against any resolution. I propose the company is so bad that I would take it for liquidation straight away. But technically speaking, the law first requires insolvency before you can go for liquidation. That's very important. Moratorium commences on acceptance of liquidation application, but this does not prevent a secured creditor at his discretion from enforcing security interest instead of joining the queue. There will be a liquidation estate, that would mean all the assets of the company will now the assets will come under a so-called liquidation estate. Whether this liquidation estate is an actual transfer of property or it's a virtual estate, the law is not clear on that, but it seems that the purpose basically is to ring fence all the assets of the company into a single estate and from there on to pay creditors. Insolvency works on what is called pari passu principle. Pari passu principle means what? That every creditor, equitable treatment to everybody, not to pay the one who is creating more pressure, because that's the very purpose of enacting bankruptcy laws. If bankruptcy laws were not there, then we work on a might is right principle. The one who has more might, the one who creates more pressure, nuisance maker gets the maximum recovery. But the very purpose of insolvency law is to put people at par and say we will do an equitable pari passu distribution of assets. Priorities as given by law. Other than that, we'll do a pari passu distribution. I'll move on. There's a very important point about pari passu, and I'd mentioned there are 4 types of avoidance transactions: preferential transfers, undervalue transactions, fraudulent transactions, and extortionate credit transactions. Now, this is a quick point. What are the different modes? This is a kind of departure, but I think important departure. Different modes of winding up companies. Companies can be wound up under what all different modes? After the code becomes implemented, what will be the different scenarios for winding up companies? Winding up on account of inability to pay will no more come under Companies Act. Winding up on the ground of inability will come under the Bankruptcy Code only. So in all cases of insolvency, that is inability or failure to pay, it necessarily has to be under the bankruptcy code. In case of financial sector companies, not under the code, in that case we have to move either under a special law to be brought by the government, if not then under the Companies Act. Winding up of healthy companies, so-called voluntary winding up, which was under the Companies Act earlier, will now have to come under the bankruptcy code. So under section 59, voluntary winding up section of the bankruptcy code, winding up of all healthy companies. Winding up on grounds mentioned in section 271 or section 433, that would mean, for example, just an equitable grounds, that will still go under Companies Act. For example, there are two members, both are not, there is a deadlock, both are not participating, both are like not even on talking terms. So it says this company is deadlocked and the company must be wound up. That is done under just an equitable clause. It will still go under Companies Act. Summary winding up of companies having assets up to 1 crore. If the company's assets are up to rupees 1 crore, the Companies Act, section 361 to 365 of the Companies Act 2013 has a summary process. Here the winding up is done not by NCLT but by CG, central government, presumably by regional director. Winding up of unregistered companies. What is unregistered company? How can a company be unregistered?
Partnership.
More than
Seven or eight partners.
seven or more partners. I mean partnership firms which have transferable shares consisting of 7 or more partners. That's called unregistered company. We have two options. Either we can incorporate the company, earlier part 9 or now whatever is corresponding section. We can register unregistered company and make it a full-fledged company.
Section
Oh.
366.
Okay, 366, right? Or if you want to wind up the company, we can wind it up under the provisions of Companies Act. So winding up of unregistered companies still comes under Companies Act, section 375, 376. Dissolution without winding up. Dissolution without winding up in case of a merger. The transferor company gets without winding up. This is done in terms of orders under section 392 of the earlier Act or section 232 3D of the 2013 Act. This is done by NCLT under section 232. Removal of name of a defunct company, so-called section 560 of earlier Act or section 248 of the 2013 Act. This is defunct. Companies not actually alive. The company is virtually dead, but the company is still on the register. The ROC may simply strike off the name of the company. This is striking off of a defunct company. The company is virtually a nullity. There is nothing in the company. So the ROC simply strikes off the name. Financial services companies, bankruptcy code is not applicable. Special law will probably come. Until then, the company. So different modes of winding up of different types of companies. Winding up of foreign companies. Indian business of foreign company. This also comes under the Companies Act. Why? We cannot obviously wind up the foreign business of foreign company, but we can wind up the Indian business of foreign company. There are several such. I don't know. In Delhi, you may not probably have, but in Calcutta, there are lots of old companies which are registered in UK, but they have business in India, primarily jute companies. They can be wound up under the Companies Act. So liquidation process, the snapshot is as follows. Passing of liquidation order. What's the impact? Liquidator takes over. All the assets get vested in the liquidator. And the board of now at this stage, board of directors ceases to have power. The company ceases to be going concern. Board of directors automatically they vacate their offices. During resolution phase, the directors were in animated suspension. They were still there, but they became powerless. They went into some kind of a hibernation. But in liquidation, the directors vacate their offices because they will no more be needed. They cannot be needed ever hereafter. So directors cease to be directors. Liquidator takes over, and he becomes the boss. Liquidation also acts as automatic discharge of all employees. So employment contracts also automatically comes to an end. All employees cease to be employees. So employees also get discharged automatically. And the liquidator will form a liquidation estate when he puts in all the assets of the company. He has power to access information systems to get information about the assets of the company. Receive and collect claims of creditors. This is what is called proving of claims. So liquidator will publish a public notice to receive and verify the claims against the company. He will invite everybody, all creditors, to prove their claim. Proving the claim, the process is first let me know how much is due to you and produce evidence that the amount is due to you. How do you produce evidence? Like it may either be borne out by records of the company's accounting records, or if the creditor has some evidence to prove, he will probably prove with some evidence that some money is due to him. That's called process of proving. Liquidator of course may deny the claim, in which case the aggrieved person, has the right to go to NCLT. Verify the claims, determine the value of claims in case of some claims which require valuation. For example, a tenancy is getting terminated because of liquidation. The landlord might say, my rentals were payable over next 3 years, give me a value for that. So liquidator may compute the value of such claims which require valuation. Creditors of course may appeal against the decision of the liquidator, and the liquidator may also use his powers of avoidance. Proceeds from sale of the assets will be paid to creditors in a certain order of priorities. This priority order is of course most important. I'll come to that very quickly. And eventually after everything is distributed, the liquidator will pay will apply for dissolution of the company. So important point, when the liquidator puts the assets of the company in a so-called liquidation estate, what assets are a part of the estate and what assets are not a part of the estate? Which of the assets of the company do not form part of the liquidation estate? This, I'm sure you understand, this is a very important point, because those assets which don't form part of the estate, they will not be available to make payment to creditors. So what are assets which do not form part of the estate? First of all, question is, what assets form a part of the estate? So all assets over which the company has ownership rights, all assets which are not in possession of the company but the company has right over those assets. The assets may not be in the company's possession, but the assets are still belonging to the company. Company's movable, immovable, tangible, intangible assets. Assets of the company in which a secured creditor has relinquished security interest. That is to say, those assets on which secured creditor has security interest and the secured creditor does not want to give up a security interest, such assets will not form part of the liquidation estate except to the extent of the residual surplus. Getting me? For example, let's say there is a factory building and the secured creditor have a charge on that. So that building will not form part of liquidation estate. The building will form part of liquidation estate only to the extent of residual surplus left after enforcement action. I made a point earlier that a secured creditor may stay outside bankruptcy and he may enforce security interest himself. How long can he take to enforce security interest? See, try visualizing. A secured creditor is not affected by the liquidation process because his right is still protected. So let's say I am a bank, I have a right over the company's factory. I think the value of the factory is good enough. My money due is 20 crores, the value of the factory is 60 crores. The remaining 40 crore will flow back and become a part of the liquidation estate. But that will happen only when I sell off the building, sell off the factory. As a secured creditor, I am not motivated enough to sell it soon. So I might probably take time. How long can I wait? As a secured creditor, how long can I drag this process? Because my delay is actually affecting everybody else. But am I compelled to sell the factory soon enough after liquidation, or can I continue to sleep over it? There is a protection in the law for that within 30 days of passing of the bankruptcy order, the secured creditor must take security action. If it does not take action within 30 days, then interest will stop after 30 days. That is to say, the interest that was accruing to secured creditor will stop 30 days after the passing of liquidation order. He will not be able to get his interest at all. So that becomes a kind of motivation for him to act soon enough and to dispose of the assets so that other creditors may be paid out of it.
Okay, suppose while enforcing this secured interest, there are challenges. It goes into litigation. It goes for say 3, 4, 5 years. So, and in the meantime, I think the liquidation process should have been completed.
Correct.
So, what will happen then?
So let's first realize, for every creditor, once the liquidation order is passed, does the interest still continue or the interest stops accruing? Once the company has been put into liquidation, does the interest on unpaid amount still continue? Loans have not been paid so far, because loans will be paid over a period of time only when money comes. Loans पे तो तभी होगा ना जब actual cash आएगा कंपनी के पास. Cash आने में time लगेगा. तो interest क्या continue करेगा कि interest बंद हो जाएगा? On passing of liquidation order, on the date of admission of liquidation application, interest stops, because उस दिन क्या हो रहा है? On the date of passing of liquidation order, the entire property of the company is getting vested into a trustee. Trustee is deemed to be officer of the court, of in this case officer of the NCLT. He's not officer actually, but he's deemed to be officer of the NCLT. So charging interest on this amount now is almost like charging interest from the court, which is not allowed by law. So interest will stop on the date of passing of the liquidation order. In case of every creditor, interest will stop from that date. In case of secured creditor, interest will stop after 30 days of passing of bankruptcy order, so as to motivate him to sell the assets soon enough. And now let's revert to another very important point, very interesting point. These are gaps left in the law, because there are no explicit provisions in law on that. But there have been lots of rulings of UK courts on this, so we are able to draw some benefit from UK rulings. Supposing we file for liquidation, eventually we find that the assets are surplus, the money is enough to pay off everything. In the meantime, interest stopped, because on day of liquidation order, the interest stopped from accruing. But later on, after paying off principal to everybody, we find the money still there is surplus. So will the surplus go to the bankrupt? That would mean the shareholders, or will the surplus be used to pay that interest which stopped accruing during the liquidation process? Are you able to get the issue? The issue is what? See, जिस दिन समझिए लिक्विडेशन पास किया हमने, उस दिन डेट थी 10 करोड़, पे करते करते साल भर लग गया, वो 10 करोड़ बढ़ के हो जाता 12 करोड़, लेकिन वो 2 करोड़ हमने क्रेडिटर्स को नहीं दिया बिकॉज आपका इंटरेस्ट स्टॉप हो गया. इवेंचुअली हमको लगा कि 2 करोड़ का सरप्लस बच जा रहा है, तो वो 2 करोड़ में क्रेडिटर्स को दूं जिनका इंटरेस्ट मार खाया है, या शेयरहोल्डर्स अपने घर ले जाएंगे. अब यहाँ पे लॉ हैज पुट अ प्रोटेक्शन दैट इट इज पेटेंटली अनफेयर दैट क्रेडिटर्स स्टॉप्ड getting the money, but shareholders will take the money home. So this amount should, that interest was accruing in the background. Interest stopped accruing. Since there is a surplus, that would mean it's not a case of insolvency. If the company ultimately we realize its surplus is left, insolvency principles can no longer apply when we find there's a surplus left in insolvency. By definition, insolvency is a case where there's a deficit. Surplus अगर है तो insolvency हुआ ही कहाँ? और अगर insolvency नहीं है, there is no question of stopping of interest. So interest stopped accruing, but it's accruing in the background, and the interest would still once again become payable if you find that there's surplus left in insolvency. I'm saying these are not clear from the ruling, from the wording of the code, because these are matters of detail. But in UK there have been rulings on this. I'll give you some more interesting rulings. There have been rulings to say that when it comes to paying off money, surplus left in bankruptcy, if surplus is eventually detected, then bankruptcy principles can no longer apply, because you cannot have bankruptcy principles applying to a company which is left with surplus. So I'll give you a very interesting example. Maybe हो सकता है आफ्टरनून थोड़ा सा डल लग रहा है आपको. Sorry, मेरे पास में हंसाने के लायक कुछ नहीं है. बहुत डल टॉपिक है. आप कहें तो मेरे पास एक किताब है, जोक्स से पढ़ देता हूँ. Okay, ये केस क्या? This is case of a aircraft manufacturing company. इस कंपनी ने एक एयरक्राफ्ट बनाया और एयरक्राफ्ट वाज ऑब्वियसली सोल्ड एंड द एयरक्राफ्ट क्रैश्ड. जब एयरक्राफ्ट क्रैश होता है, एवरीवेयर इन द वर्ल्ड व्हेन द मेजर एक्सीडेंट हैपन देयर आर क्लेम्स ऑन द एयरलाइन कंपनी सेइंग यू वर द वन रिस्पांसिबल, आपका एयरक्राफ्ट डिफेक्टिव था, 100 आदमी मर गए. क्लेम्स आर ऑलवेज फाइल्ड अगेंस्ट एयरबस इंडस्ट्री और एनी ऑफ द मेजर एयरक्राफ्ट कंपनीज. बाय दैट टाइम द कंपनी हैड फाइल्ड फॉर लिक्विडेशन. The company, not that it filed for liquidation after the accident, the company had filed for liquidation already. After that, the aircraft went into accident and there were substantial claims against the company. The insurance claims apart, the claims were admitted by several courts in Europe, admitted claims. But when the claimants went to the company was no more there, but the company had gone into liquidation. Either क्या हुआ, the company went into liquidation as a bankrupt company, but eventually there was a surplus left on liquidation. So once the surplus was about to go to shareholders, during that process the claimants to whom compensation was payable, they went ahead and said, we have compensation payable to us. The company flatly declined. The company said, Once the company is declared to be bankrupt, the company stop to be going concern altogether. There is no question of a claim on the company when the company become a bankrupt company, because once the company becomes bankrupt, subsequently there is no question of any claim at all. So the claim doesn't lie. At the same time, there was a surplus. So applying principles of equity, courts held that you cannot have money flowing back to shareholders. At the same time, creditors are not getting the money. So nothing doing, this money will not go to shareholders. The money will still be used to pay off the claimants. So very often gaps in law are filled up by courts. Insolvency law is to very large extent judge-made law. Part of it is statutory law, but a lot of it is judge-made law. Judges fill up gaps. Judges have applied wisdom, equity principles to say there is no question of money being taken by shareholders when creditors are not being paid on account of insolvency proceedings. So interest will continue to accrue for everybody in the background. If at all there is a surplus detected, interest would still be paid. Now there are further questions of detail, whether interest will be paid at original contractual rate or a uniform rate to everybody. किसी का 10 था, किसी का 12% था, किसी का 9% था, उसी रेट पे पे होगा या यूनिफॉर्म रेट पे होगा? Those are questions of detail. I think at rule making some stage, maybe the rule maker captures these questions. But as of now, suffice to say, interest will be payable if there is surplus left on bankruptcy. But for the secured creditor, to sort of motivate him to take action within 30 days, his interest accrual will completely stop after 30 days. If it does not take action within 30 days, he will not be able to claim interest at all. Whether that delay is because of his, volition, or delays for reasons beyond his control, delays because of litigation or whatever, there is no answer to that. 30 days after date of bankruptcy, secured creditor will stop claiming any interest at all, even if there is a surplus left thereafter. So it's a very special provision to motivate the secured creditor to take action soon. Okay. What will be excluded from the assets of the company? Very, very important points, and I think they're very important point to make here. Number one, assets in possession of the company but owned by third party. Assets which are in company's possession but they are owned by third parties. Lease assets, rented premises. But more than that, this exclusion is dismissing a very old insolvency principle called doctrine of reputed ownership. Claiming to be the reputed owner. Reputed owner किसको बोलते हैं? मेरी जिसके पास प्रॉपर्टी है वही प्रॉपर्टी का मालिक है. If I have possession of property for last 20 years, I am reputed owner. ये प्रॉपर्टी लॉ में ऐसा है. 20 साल से आपके पास प्रॉपर्टी आपके पास है, there is no other claimant, you become the reputed owner. The insolvency law में reputed ownership was respected, that it was recognized as the property of the insolvent if the insolvent has continued possession of property for a long number of years. But this actually dismisses that old principle that assets which are owned by third parties, even if they are in possession of the company, they will be regarded as excluded. They will not be taken as the insolvent's asset. Assets in security collateral held under netting contract. This is also very important provision. Provision of set off or provision of netting off of contracts. Let me illustrate that. Supposing A has money to pay to B. A को देना है B को, समझिए 2 करोड़ रुपए. A को B से लेना है, समझिए 5 करोड़ रुपए. ठीक है? A has to pay to B 2 crores, B has to pay to A 5 crores. नॉर्मल क्रॉस में क्या होता? 3 करोड़ दे दिया होता. अभी समझिए A इंसॉल्वेंट हो गया. तो A को जो 5 करोड़ मिलना था, कैन B से कि 5 करोड़ तुरंत दूंगा 3 करोड़ दे लो. Because money payable to a bankrupt, you need to pay fully. और B को जो A से मिलना था उसका क्या होगा? उसके लिए प्रायोरिटी ऑर्डर मानना पड़ेगा. हो सकता है 5वें छठे लेवल पे आ रहे हैं जहाँ पे रिकवरी है 20 पैसा इन रुपी, 20 पैसा इन रुपी, तो आपको 2 करोड़ के बदले हो सकता है 4 लाख ही नहीं मिले, जबकि आपको अपना 5 करोड़ पूरा देना पड़ेगा. तो क्वेश्चन ये उठता है कि am I entitled to net off the obligation or do I have to settle my obligation in full and bring the insolvent based on the priority order? This is called law of set off. So statute says, the law says that if netting off will be allowed in case of those contracts which are settled by centralized counterparty netting. For example, स्टॉक ब्रोकर्स के केस में क्या होता है? अगर आपको पैसा देना है, आपको पैसा मिलना है, आपको नेट पैसा मिलेगा. पूरा देके पूरा बैंकर्स के बीच में सेटलमेंट कैसे होता है? HDFC बैंक, स्टेट बैंक ऑफ इंडिया, जब क्लियरिंग के लिए जाते हैं नेट सेटलमेंट होता है. So if net settlement is done in a centralized counterparty system, then setting off is still allowed. Normal जो contractual setting off है, law remains silent on that. While the law is silent, but the common law principle is that set off is still allowed in case of insolvency also. That would mean if I have mutual reciprocal obligations, I can actually make a net settlement and pay off the net amount only. So while this is not statutorily incorporated, but the common law principle of set off is applicable in insolvency situations as well. Personal assets of a shareholder. In case of corporate bankruptcy, there is no question of personal assets of a shareholder forming a part of the liquidation estate. Now, very important point, assets of any Indian or foreign subsidiary of a company. If you realize it, this will be a major issue. Assets of an Indian or foreign subsidiary. Holding company goes into liquidation. Assets are parked in subsidiary companies. Will the liquidator be able to get the assets of subsidiaries? What will the liquidator get? Will he get the shares of the subsidiary or will he get the assets of the subsidiary? So what will he do with the shares? Shares will be of, shares may be of some use. If you are able to sell off the shares as ownership interest in the subsidiary, perhaps yes, but very often the corporate control is so complicated and there might probably be one more layer between the subsidiary and the ultimate company where the assets are. There might be some insulation device whereby even though you own the upstream company, you may not be able to sell off the downstream company. I hope you're getting me, na? ऐसा बहुत common है. कंपनी बी और कंपनी डी के बीच में कंपनी सी घुसा देते हैं, उसमें किसी और का प्रेफरेंस शेयर या किसी और का वोटिंग इंटरेस्ट डाल के, such that even if you own कंपनी बी, आप कंपनी डी को टच नहीं कर पाओगे. तो ये जो concept of lifting or piercing of corporate veil, that you may disregard the corporate veil and treat the assets of the subsidiary as assets of the parent company, that has actually been completely contradicted by the law. To my personal understanding, there was no reason to put this clause because it's a common law that you cannot touch the assets of subsidiary if you have actually the holding company is going into bankruptcy. But by not incorporating this exclusion, the equitable power of a court to disregard corporate veil and lift the corporate veil and treat the assets of subsidiary as the assets of a holdco, that power would have been exercised. But by incorporating a specific provision, we have done a damage and allowed companies to so conveniently organize their affairs that all the major assets can be parked in subsidiaries and there might be insulation devices in between, so parent company can take debt. So जो lender parent company level पे debt दे रहा है, many lenders are actually giving loans to upstream companies. I'm sure you would have seen it in many common life cases. Banks give loans to holding companies which in turn transfer the money to subsidiaries. Assets are parked in subsidiaries. Somewhere we are able to control the subsidiaries even though the parent defaults, bankers would be able to do nothing. At best they'll be able to sell off the shares of the shares held by the holding company, but there might still be complete protection because of some insulation device. So this actually will go against the interest of creditors. And I can caution, it would be very unwise on the part of anybody to give a loan at holdco level. If at all you are into financial business, you must always try to structure the lending so that you have a direct loan to the operating company instead of giving a loan at the upstream company, because the upstream company will not be able to exercise any control on the assets of the ultimate company. Assets acquired on hire purchase are excluded because they are assets of a third party. Next question. So distribution order of priorities. We've discussed this.
Proposition of asset of Indian subsidiary company. So even if at some point of time loan is given to any operational company, so after the receipt of the loan, it can organize its affairs and it can set up subsidiary company and transfer that funds there.
That would be siphoning of funds.
Yeah, of course.
Siphoning of funds?
You cannot siphoning of the funds like create a subsidiary and invest into that heavily, uses that entire amount of loan and subsidiary and the subsidiary purchases the assets.
So every time a banker gives a loan to a company, the banker gives it for a particular purpose of the loan. If the money is not used for that purpose, the money is used for on lending to somebody else, that becomes a clear case of siphoning of money and that is what is called a willful defaulter. And the willful defaulter tag can be very easily applied to all such cases. Conscious bankers, I mean, it's a different thing that bankers are not mostly all that conscious. And that's why bankers very often use the services of practicing company secretaries to give a due diligence report.
Use of money.
DD report becomes very critical. आप में से बहुत सारे लोग DD report देते होंगे bankers को be very careful that अगर आप ये misapplication of money और siphoning of money point out नहीं करते हैं, you are simply signing a kind of perfunctory DD report. आने वाले दिन में कोई न कोई banker कोई professional को responsible hold करेगा. Because lots of loans go bad, there is a DD report by the professional saying everything is okay. And money has been siphoned off. Some banker at some stage will impose a claim on the professionals कि आप you are responsible. 400-500 करोड़ का liability ठोकने वाला है कोई बैंक. मेरे ख्याल से it would be very serious because lots of professionals I think most perfunctorily give a DD का एक format बना के रखा है छपा मार के देते हैं. Client बोलता है ऐसे कर दीजिए वैसे कर देते हैं. It's a very serious business because you're giving a report to a lender. Lender is relying on your report to say whether everything is okay or not. DD report का provision क्यों है? Because RBI said bankers cannot be exercising, at individual borrower level their own precaution. Let there be professionals who will act as eyes of the bank. So eyes of the bank होने के नाते you have to actually exercise the same discretion that the banker would have exercised. Anyways, back to the point. So exclusions include assets of Indian or foreign subsidiaries. Priority order of distribution, very important point. So priority order of distribution, first item in the waterfall is insolvency resolution cost, which we said includes the cost of borrowing during the resolution period. Then debts which will rank item number 2, these two debts rank equally, that is debts of claims of a secured creditor who has relinquished security interest. I was earlier saying that's a very tricky call for a secured creditor as to whether he should stay outside the bankruptcy process or join the bankruptcy process. What are the factors based on which the secured creditor will take this decision? So I'll give an example. One very quick example. Let's say my claim is rupees 10 crores and I have security interest on assets worth 20 crores, 15 crores for example. This is a no-brainer question, right? Because this case, there's not even a doubt that I would stand to benefit if I stay outside the bankruptcy process. There's no point in me joining the bankruptcy process. My loan to value ratio, loan is 10 crores, value is 15 crores. I should definitely stay outside the bankruptcy process, realize the assets. But mostly in situations of bankruptcy, it would be other way around. My claim will be 15 crore, the value of asset will be 10 crores. If my claim is 15 crore and the value of the asset is 10 crores, I would say loan to value ratio is about, let's say, 150%. My loan is 15, value of assets is 10 crores. 150%. So I have to assess what? My assessment will be what will be the recovery rate. If I enforce security interest, I'll first be able to sell assets worth 10 crores, by which I realize 10 crores. Remaining 5 crores, what will happen? Remaining 5 crores will be, you can see item number 1, 2, 3, 4, 5. See item number 5 ka second bullet. Debt owed to a secured creditor for an amount unpaid following enforcement of security interest. Hope you are able to read from this thing. Fifth item ka second bullet. So unsecured part, that is unrealized part of a secured debt, becomes item number 5 in the waterfall. Whereas if I were to relinquish security interest, I'll be item number 1. So the call that I have to take is, what is the loan to value ratio for the company as a whole? And my loan to value ratio is 150%. Loan is 15 crores, value of assets is 10 crores. If I take the company as a whole, what's the loan to value ratio? For example, the assets of the company are 100 crores and the total obligations are 120 crores. If the assets of the company are 100 crores, total obligations are 120 crores. My claim is 10 crore. Assets of 100 crores will be available to pay off my claim of 10 crores plus other creditors who are ranking at par with me. In any event, the payout in that case will be far higher than getting 10 crores out of 15 crores. Are you getting this point? If I stay outside bankruptcy process, the entire asset of 100 crores will be available to make payment first to secured creditors. I am one of them. There might be others as well. So total amount of secured creditors for the company as a whole and total amount of assets of the company versus my asset and my loan outstanding. Which of these two gives a better recovery rate? So the entire exercise is in which process, whether by staying outside bankruptcy or by joining the bankruptcy process, will my recovery rate be higher? The question entirely is one of which of these two will produce a better recovery rate. So that's a basis on which a secured creditor decides whether to stay in the winding up process or to stay outside it. Wages for last 12 months in case of workers, and wages for past 20 wages beyond 24 months in case of other employees. Financial debts due to unsecured creditors. Item number 4 is unsecured creditors financial dues. That's item 4. Item 5 is central government claims. So you can see from what was earlier item number 1 is now item number 5. Pari passu with the unrealized amount of other secured creditors. Item number 6 is remaining debts and dues. This obviously includes operational creditors. So operational creditors come at item number 6. 7 preference shareholders, 8 equity shareholders, and you can see last item, fees payable to liquidator shall be now this is not last, it's not last item. The fees payable to liquidator will be proportionately determined. That would mean the total fee payable versus the total amount payable to other creditors. If other creditors lost, for example, 10%, liquidator will also lose 10%. Other creditors lost 50%, liquidator will also lose 50%. The amount lost or sacrificed by the liquidator on account of his fees will be proportionate to the amount sacrificed by other creditors. Does it come clear? That would mean the liquidator is now motivated to maximize the payout to other creditors so that his own payout is also maximized. To the extent other claimants suffer, he will also suffer. So it's his fees are made. I mean, he becomes a partner in the entire distribution process. So he would be getting proportionate to other creditors. That the creditors committee? I mean, the creditors committee will, the liquidator and creditors are virtually into a contract. Liquidator, for example, says I need to be paid 5%. Creditors committee has to sanction that. Who appoints the liquidator? The one who files liquidation application will first name the liquidator. But the creditors committee may eventually either keep the same person or may replace a liquidator. So liquidator is the appointee of the creditors, and the creditors also determine the amount payable as also the control on the powers of the liquidator. I mean, whatever things the liquidator will do, will not do, for these things you have to ask the creditors, etc. All of these are fixed by the creditors committee. So creditors committee has a full control on the working of the liquidator. Certain things the liquidator can do without approval of creditors committee, but for lots of other things he has to take sanction of the creditors committee. For example, any related party transaction he has to take sanction. And the creditors committee may put further controls or further factors on the powers of the liquidator.
Suppose if looking at the financial state of the company, if the potential appointee knows that he is only able to get 10% of his fee, then why would anybody accept liquidator position?
So he would accept, I think, price himself accordingly. He'll probably say, since I expected payout of only 10%, I have to increase my fee such that my in-pocket is, what I expected. He'll have to impose certain, correct. ऐसे ही estimate करेगा ताकि मेरा in-pocket is, what I was anyway expecting. Sorry? नहीं, process में मिलता रहेगा तो, but only as he continues paying. For example, security credit दे दिया, उनको full दिया तो अपना पैसा full ले लेगा, proportionate पास पैसा full ले लेगा. फिर next stage वाले को समझे 80% दिया तो उसका 80% अपने आप ले लेगा. They will continue progressive payment of the payment of liquidator fee will be progressively done as the creditors are progressively paid. So that the last dollar he gets will when he pays out the last amount to the creditors. Okay, very important point now is what about contractual priorities? For example, let's say on single asset, on one single asset we have two charges. First charge, second charge. This law says that every secured creditor will be put at parity. All secured creditors have a mutual parity. can see item number 1 is secured creditors. We are not distinguishing between first charge holder, second charge holder. In the loan contract, there's an order of priorities: first charge, second charge, third charge, for example. So will that priority of charges remain even when the company goes for liquidation, or will the priority get all rubbed off and be only one priority, every creditor is taken alike?
At least that should be respected because that's
Absolutely.
their decision.
Absolutely. Similarly, there's a kind of loan called subordinated loan or subordinated bonds. Subordinated loans and subordinated bonds are those which are after the claims of this last part, sixth part, any remaining debt. Subordinated loan or subordinated debt, you would have probably seen several banks and financial institutions, NBFCs particularly, they come up with an instrument called subordinated bonds or subordinated loan, which is subordinated to claims of every other creditor, including unsecured creditors. So if the company in question has issued a subordinated claim, when the company goes for liquidation, will the subordinated claimant become at par with any other unsecured creditor, or will he come after unsecured creditor? Obviously, this also has gone, while the statute seems to say that everybody will be treated at par, but courts have consistently held that this will be after number 6, this will be number 7, for example. And the courts have said that bona fide ranking of priorities among creditors will still be respected, even though the statute seems to say everyone will be taken at par. Because the purpose there is the purpose will be defeated if everybody was to be taken at par. So this is based on ruling of UK court in a ruling called SSRL realizations. It's a UK ruling. Okay, let's. I said the liquidator has powers to avoid preferential transfers, transfers of assets for inadequate consideration. So preferential transfer is one where undue preference is given to somebody. Next is called undervalued transaction. Undervalued transactions mean what? Undervalued transaction could be of both types, either contracting a liability and giving an asset which is of higher value, or transferring an asset and getting cash of lower value. I sold off a building worth 10 crores for a price of 2 crores. That's undervalued transaction. Vice versa, I bought an asset worth 2 crores and I paid off 10 crores worth of money. That's also undervalued transaction. So consideration received versus consideration paid, if these two are not proportionate, the liquidator may challenge these transfers, and the reach back period is 2 years in case of related party transactions and 1 year in case of novel transactions. Very often in legal parlance, due to give a due diligence report saying whether the transaction in question is liable to be challenged on account of clawback rights under liquidation, under insolvency laws. For example, this could be a challenge to everybody. If, for example, somebody is giving a loan to a company and is acquiring an asset by way of security interest, tomorrow somebody could come and say that this loan was taken, it was undue preference. There were assets which were, the assets of the company were not sufficient, and this particular creditor was given a preference because security interest was created in favor of this creditor. So this could potentially be a challenge to every creditor, but we have to actually take a view on whether this transaction is bona fide for good consideration, or is the transaction being done to show a particular favor to somebody. Fraudulent transaction can be challenged without any limit as to time. An extortionate credit, there is a protection for transactions done by regulated financial sector entities. For example, a loan given by a bank or a loan given by an NBFC cannot be challenged on the ground that it's extortionate credit transaction. Extortionate meaning too high rate of interest. If the company has taken a credit facility at too high a rate of interest, a liquidator may disown the liability. He might say, I just don't want to carry on the liability. Extortionate credit. So that's amounting to extortion. Let me straight move to individual insolvency now and give a quick voluntary liquidation. We have discussed already that this is applicable in case of solvent companies, and the process, there's no time limit as such, but hopefully the voluntary liquidation can be handled fairly quickly. So I'll proceed straight away. Appeals, any order of NCLT is appealable. Every order is appealable. Wherever there is a question of order, the process of order of NCLT is the same as under Companies Act. That would mean principles of natural justice are applicable. The moment we say principles of natural justice are applicable, what does it mean? It means NCLT cannot pass any order without hearing all concerned parties. That would mean there has to be notice of hearing, there has to be there has to be hearing. NCLT has to hear all parties and then arrive at a reasoned decision. Once the NCLT gives a decision, any concerned party can take it to NCLAT. NCLAT, okay, between current provisions of Companies Act, we have a right to take a matter to, think of, let's say, CLB. Orders of CLB are appealable or were appealable to the High Court only on grounds involving question of law. You could not have taken to the High Court a question of fact. You only could take a question of law. And as Sybil cannot keep history of my default, because if it continues to show me as a former bankrupt, then I'll never be able to live with a high head in the society. But in India, I'm hoping that similar rules will come by way of rules, but as of now there's no provision. But of course, past history of bankruptcy will be shown. How long? That's a question. US also probably similar. So the issue is, I can become bankrupt again. There's no bar on becoming bankrupt again. I can become bankrupt once, get a discharge, live moderately for 1 year, and then come back to same my old habits and become bankrupt all over again. Second time bankrupt, there's no special provision on second time bankruptcy. Since we were drawing on UK law, several things we actually made a mistake because we drew on UK law. UK law का history नहीं देखा हमने. UK law में पहले discharge का period था 3 years. The bankrupt would get a discharge after 3 years. अब 3 year को घटा के उन्होंने कर दिया 1 year. अब 1 year तो किया, लेकिन उसके साथ एक और provision आए थे, which is called bankruptcy restrictions order. That the court may, while granting discharge, impose restrictions on the bankrupt, so that it does not become bankrupt again. तो probably ये बोलेगा कि आप क्लब जाना बंद करो, ताश खेलना बंद करो, वगैरह वगैरह. I'm giving examples, of course. ताश खेलना खराब बात नहीं है शायद. तो but for all of you surely not, because Saturday afternoon आप यहाँ बैठे हैं, ताश कैसे खेलेंगे? Okay. So bankruptcy restrictions order were there in the UK law, but there is no corresponding provision in Indian law. There is no restriction. But after discharge, there is no restriction at all, which is actually a mistake, because UK has, after a lot of deliberation, thought that people might actually develop this as a kind of habit, as a kind of luxury. So there should be restriction that you are not using bankruptcy as a place of pilgrimage. एक बार जाके पाप दो फिर दोबारा पाप करना चालू कर देते हैं. तो ये जो है कुंभ का स्नान नहीं है. And therefore, it should actually, there should be restrictions on a bankrupt as well. But our law does not have a bankruptcy restriction order. I am almost certain that during the rule making stage, this issue may come up. So there is no bar on becoming bankrupt again in case of any normal insolvent. Moving further. So I'll fresh start. We've discussed already. Let's move further. Insolvency application fails. Resolution fails, then we'll file for bankruptcy of the individual. Once again, bankruptcy application will be filed before the adjudicating body, that will be the DRT, either by the creditor or by the individual himself. This is within 3 months of passing of the order by adjudicating body under section 110, that the resolution plan has failed. And when the bankruptcy order is passed, the effect of the bankruptcy order is immediately all the assets of the bankrupt will vest with the trustee. The estate of the bankrupt will be divided among the creditors in the certain priority order. There will be bar on the creditor to commence proceedings. Creditors cannot start proceedings. Secured creditor, of course, may take enforcement action. He may enforce security interest by staying outside. Other creditors cannot start action. For example, DRT claim, etc. You cannot make a claim for recovery of money from the entity. And modification or recall of bankruptcy order. Modification or recall of bankruptcy order actually means what? Once everything is paid, the individual has not got a discharge, but assets were sufficient to pay off everybody. So there is no reason to continue the bankruptcy order. The 12-month discharge is not mandatory period. That would mean if we have paid off all the creditors before 12 months, then you can actually go to DRT and ask for annulment or recall of the bankruptcy order, because if we find out that the assets were sufficient, we can say the person was not a bankrupt to begin with. Therefore, the bankruptcy order will be completely recalled, and the recall of bankruptcy order would mean as if there was no bankruptcy at all. But it would erase the history of bankruptcy completely, and the individual will be taken as a normal, healthy person. Estate of the bankrupt, vesting happens automatically. What is included in the estate? All property belonging to the bankrupt, all property over which he has right to exercise any claim, property which by virtue of this law is comprised in the estate. That would mean, for example, using any avoidance transaction, etc. Liquidator brings back property that will also form part of the estate. Excluded assets, I mentioned earlier, household goods, utensils, workmen's tools, etc. They are not part of the estate, they will be excluded. Property held in trust. Anything which the individual is holding in trust, is a trustee, the property is not his, is simply a trustee. Even those assets will be excluded. Assets held in trust, what does that include? For example, if the individual has taken a loan from somebody, can he say that I am only holding this money as a trustee? It's not my money, I am holding it as a trustee. Amount that is holding as a borrower versus amount that is holding as a trustee, what's the difference? Individual in question says I am owning a house, but the house is not mine because I have declared the house in charity. So I am merely a trustee for the house. Can he therefore claim that this house is not mine because I have given it for public charity? Yes? If the individual continues to stay in a house and says I have declared this house for public charity, मेरा कोई हक नहीं है. So this house is not mine, the house is dedicated to public charity. I am merely a trustee.
No.
Thereby can he save that house from getting into the bankruptcy estate? So issue is, if you are a trustee, you cannot be beneficiary as well. Beneficiary means what? Who is deriving the benefit? A trustee is somebody who's not holding beneficial interest in the property. Trustee is somebody who's merely a fiduciary and not a beneficiary. If he's staying in the house, then he's the beneficiary, he's not the trustee. Right? So he cannot claim that assets which are with him, which are accruing to his benefit, are assets held by him in a trustee capacity, because actually he is deriving a benefit. So this is a very common device used by people to save assets from becoming a part of the bankruptcy estate. But the differentiating line is, are you deriving a benefit from the asset? If yes, then you cannot claim the asset to be held by you as a trustee. A trustee cannot be using the asset for his benefit. Trustee has to use the asset only for the benefit of beneficiary.
Gift.
Assets gifted out.
Same, yes.
So gifted out to that.
Same manner, but still I am using.
So I have gifted the asset out. Na? We said during the reach back period, any gift given by him 1 year prior to bankruptcy or 2 years to a related party will come back. Liquidator will question. Let's say the gift was done 5 years back. In that case, if the liquidator proves that this was a fraud on the creditors, he can still claim the asset back.
Still trustee and beneficiary thing will also come.
Trustee beneficiary anyway will come, but if it's transferred any asset for undervalued consideration, either by way of a gift or by way of undervalued consideration, the trustee may reclaim, claw back all such assets. What about gifts given by company during
So
normal
what about a gift given by a father to the daughter in her marriage? Whether they will come back?
I can understand the concern, man.
No, I'm married. No.
You're working for lots of, I think you're talking for lots of females who probably might have similar concerns. I think ये ऐसा है customary gifts, gift given by a father to a daughter at time of marriage. Was it done for the purpose of defrauding the creditors? Answer is no. Right?
तो क्या मतलब प्लान और शादी की बात कर लेते हैं उनके वो
Then plan will be
इंसॉल्वेंट डिक्लेयर कर लेंगे.
I mean, if it's part of the plan, questionable hai. I mean, I will incur a lot of bad feelings among people here if I give an answer. So I'll stay without giving an answer. Right? I'll save my skin. But yeah, the answer is simple. If there is any undervalued consideration, the person goes bankrupt. Any lavish expenditure also can be questioned. Lavishly went and spent, let's say, to whoever. I mean, he gave money out, threw money out. The trustee can question the wasteful expenses also. It's undue preference. Wasteful spending, you'll probably say it was done without consideration, therefore bring the money back. So as I mentioned, the right of a third party means second layer party. Immediate transacting party cannot claim a relief saying I was not aware. For example, the daughter of the individual cannot say I was not aware. Right? So daughter will probably not get a relief, but if daughter in turn has sold it to somebody else, a jewelry shop, then probably the jewelry is protected. Okay. What about business gifts? Company giving bonuses to its employees. That's also a gift actually. So can the liquidator say the bonus आपने गलत दिया वापस लाइए इसको? No. So what is customary for business? Customary gifts in business, that is exempted. But undervalued transactions, it still protects customary gifts required for business purposes. But of course, the individual in question starts giving lavish gifts. It's like, for example, let's say throws a lavish party and says gives lavish corporate gifts. The liquidator can still question. In fact, there are codes of conduct for liquidators from international bodies, and they say that liquidator must first start examining the conduct of the bankrupt over the last 1 to 2 years, that is the period prior to bankruptcy, and see what all expenses has incurred. If any out of course expenditure, something which is not in ordinary course, he must start questioning that. Generally speaking, transactions with arm's length parties normally are protected. But something which does out of ordinary course of business, showing a kind of extraordinary lavishness, extraordinary generosity, all of these are questioned by the liquidator. So this is one of his jobs. A liquidator must always start examining closely transactions done by the bankrupt, because it's most common intuition on the part of the bankrupt that he starts, parting with assets in preparation for bankruptcy. So discharge order, as mentioned, discharge order is automatic after 12 months and can happen even before 12 months. If the assets of the individual already been distributed, nothing remains, then the individual may apply for discharge even before 12 months. But after 12 months, necessarily, he will get a discharge. Once again, UKL law, there is a provision for suspension of discharge, extension of tenure of 12 months. 12 months can be extended based on the liquidator's contention. There is no such power explicitly in the Indian law, but I am almost sure that such a power will be there in the rules. That liquidator may sometimes apply to, in this case the trustee may sometimes apply to DRT to say please don't grant discharge in 12 months because the conduct of the individual has not been fair. Situations where the extension of time is granted mostly is where the conduct of the bankrupt was not fair. For example, he was not disclosing information, he was hiding some assets, he was living lavishly, etc. He started contracting debt once again. So his conduct shows that he is not honest person. Then the liquidator may, or the trustee may, require extension of the tenure. Proof of debt, I mentioned, every debt requires a proof. Whenever a creditor would like to make his claim, he has to prove his claim. There's always a process. So, okay, supposing the trustee, once he takes his office, he gives a public notice that within 21 days prove your claim. At that stage you did not respond. You are a creditor, you did not respond. Right? So time is gone. Now in the meantime, the liquidator, the trustee started distributing property. And once, let's say 1 year is over, property is just about to be distributed completely. At that stage you wake up that there is a claim that you also had. Can you file a claim at that stage? So process is that before the final dividend meaning the last distribution, before the final dividend, once again the trustee puts a final notice, final public notice that this is the last distribution call. If you have a claim to make at this stage also, please come forward, because if you come thereafter, there is no way anything will be payable to anybody. So normally before the final distribution, a last public notice is once again put by trustee to invite all those residual creditors who might claim money to be payable. Priority of payment is similar to corporate credit, with the difference that there is no distinction between financial and operating creditors. Adjudicating bodies, like I mentioned, NCLT in case of companies, DRT and DRAT in case of individuals, insolvency professionals and insolvency professional agencies, IPAs and IPs. How will the institutional framework go? So adjudicating bodies, there are two, DRT and NCLT. Appellate bodies are DRAT and NCLAT. Insolvency professionals are practitioners like us, for example, CSA, chartered accountants, lawyers. They are normally members of a professional agency. And for example, ICSI is a professional agency or ICAI is a professional agency. So it will be for IBPI, the board, to decide who will be the professional agencies who will be entitled to authorize their members to practice as insolvency practitioners. I am assuming, based on, let's say, UK experience and based on whatever little feedbacks we got from, let's say, the not necessarily the ministry, but even the BLRC, which was responsible for framing the law, that at least to begin with, maybe the Bar Council, maybe ICSI, maybe ICAI, ICWI, they will probably be recognized as IPAs and they will be entitled to grant IP recognition to the members. Not every member, of course. As Pawanji was also saying, that they might, all likelihood there will be an exam. And like in UK also there is an examination. So people who pass that particular examination, they are granted the authorization to act as insolvency practitioners. There will be codes of conduct. Who will frame the code of conduct? The code of conduct will be framed by the respective institutions. ICSI, ICAI will frame respective codes of conduct. Codes of conduct already there are. For example, we have professional code of ethics we already have. But for bankruptcy practitioners, there is a separate code of conduct by ICAEW, Institute of Chartered Accountants of England and Wales. Similarly, Insolvency Practitioners Association of UK. There are separate codes of conduct for insolvency practitioners on top of the codes of conduct applicable to every professional. What's the purpose of these codes? But these codes put in place additional safeguards. For example, duty of acting diligently with the liquidation process, duty of avoiding conflicts of interest. These are basic principles contained in the codes of conduct, and obviously enough these codes of conduct are mandatory for everybody. And breach of code of conduct will A, lead to cancellation of authorization, and B, might lead to prosecution as well. I had mentioned earlier that liquidator is recognized as an officer of the company, so liquidator is also liable for being prosecuted as an officer in case of any default. What happens to income tax returns? The company is under liquidation, voluntary or compulsory. Will we still be filing tax returns until the company is dissolved? Answer is very clearly yes. This question was answered several years ago by Supreme Court ruling called Marshall Sons Limited, that until the company is dissolved, the company is still existing. Till we get a dissolution order, the company is still existing, so the company earns income, and then you still have to file returns of income. So income tax returns will continue. Of course, the income tax return will now be filed by liquidator. OL now liquidator. Of course, the company's bank account, etc., will all be run by the liquidator. Liquidator may grant delegation of authority, might give to officers of the company, but technically he is the one who has the right to handle all bank accounts also. Some provisions of Companies Act are applicable to the bankruptcy code also. For example, every correspondence of the company, every stationery of the company must say the company is under liquidation. When you write the name of the company XYZ Limited, you must now say under liquidation. But I make a very specific mention that everything that goes from the company shows that the company is under liquidation. In case of individuals as well, if the person is an undischarged bankrupt, in all his business dealings he has to intimate everybody with whom he does business to say that he is undischarged bankrupt. So that acts as a kind of notice to everybody that please do take your care because you are dealing with a person who is undischarged bankrupt. Separate bank account also. Every money will go into separate. Absolutely. XYZ company liquidation account. Every money payable to the company will go into a separate bank account called XYZ company liquidation account. Most of the bankers are not even familiar with what is liquidation account. So operationally bankers don't understand this. Many banks don't understand, so you probably have to choose the bank which understands. In our experience, we found most of the banks, they consult their operations manual. There's no section dealing with liquidation companies because they say हमारे operation manual है नहीं. We don't know what is liquidation account. So they are unaware of this, but you need to sometimes convince them. Otherwise, choose the bank, whichever bank is comfortable to open the account. Acha, what about those creditors to whom money is due, money is payable, but they don't come for claiming the money. So you will find lots of creditors who are in the company's records, and therefore the liquidator will send, let's say, checks to them, but those people don't encash the check. Unclaimed payments to creditors. What will happen to those claims? IPF is applicable to unpaid dividends, unpaid interest, etc., etc. So winding up के case में IPF provision is not applicable. So money will go to consolidated funds, that's RBI, but it goes after 15 years. Unlike IPF, which is 7 years, unpaid money to creditors. I don't know, IPF वालों को समझ में नहीं आया कि यहाँ पे पैसा है निकलने का. I don't know. There's a fund called Insolvency Bankruptcy Fund of India. I'm sure you would have said that you would have seen in the press also recently. The MCA got the control of the Insolvency Bankruptcy Fund of India. Insolvency Bankruptcy Fund तो है, लेकिन fund में पैसा कहाँ से आएगा मेरे को नहीं मालूम. Because हो सकता है कि this 15-year-old money, unclaimed money, which is normally goes to Consolidated Fund of India, would probably come to the Insolvency Bankruptcy Fund of India. There was once a proposal for insolvency cess. स्वच्छ भारत सेस की तरह insolvency cess भी लगने वाला है, कोई समय लग जाएगा शायद. So that cess may also go to the bankruptcy fund, but currently there's no clarity on where will money come from into the fund. But after 15 years the money goes into Consolidated Fund of India, that's RBI's account. So that's as far as payment of money by liquidator is concerned. Can the liquidator be replaced? In case of companies, can the liquidator resign? The code has a provision for resignation, he can resign, he will then be replaced by committee of creditors, and even against his wishes, the creditors committee may replace him. Similarly, in case of individuals also, the bankruptcy trustee, he may be replaced by committee of creditors. So normally speaking, the upper control on the entire process remains with the creditors. Creditors decide whether who will be the liquidator or the trustee in liquidation. So the insolvency professional bodies, and well, of course, jurisdiction of civil courts is completely barred. Civil courts don't have any jurisdiction at all. So wherever there is a matter vested in the NCLT, NCLT, DRT or DRAT, there will be no jurisdiction of civil courts at all. For example, for determination of matters such as partition, title, etc., that will still be done by civil courts. But to the extent a matter is before DRT, DRAT, NCLT, NCLT, the jurisdiction of civil courts is completely barred. Information utilities. Pawanji was making a brief mention of that there will be some central level information utilities for storing information. What kind of information? Most importantly, information about charges, security interest. That process has already begun, as the lady at the back was saying. CERSAI has now been extended to apply to all kinds of security interests.
Movable and
all movable, immovable,
IPR.
I mean assignment of receivables, everything. January 2016 notification virtually includes all kind of security interests. And the proposed amendment to SARFAESI Act puts CERSAI, as a replacement of companies registry also. Going forward, most likely, registration of charges under the Companies Act will also be done with CERSAI. So that there is only one registry which stores all kind of charges by all kinds of companies as well as LLPs or other borrowers. That is little futuristic, and other information utility will be, for example, something like CIBIL or something like RILC, which is storing data about corporate defaults or credit information about individuals. All of these are called information utilities. So each of these will also come under control of the IBBI. So information utilities, insolvency professionals and insolvency professional agencies such as ICSI, ICAI, that will be the institutional framework. All of these will act under the control of the IBBI, which is regulator acting in control of the non-adjudicatory part. Adjudication, of course, comes under control of NCLT and DRT, which are responsible to the courts. I think so. We're talking about insolvency bankruptcy fund. We talked about that already, and that this law overrides to the extent of any inconsistent provision. The provisions of this law override anything else contained in any other law. Until the board is constituted, central government will exercise powers. That would mean till the IBBI comes into existence, authorization of insolvency agencies, etc., will all be done by the central government, which would mean MC. The MC has got a control over the law. I think in terms of I would say basic presentation, this is what I had to talk about. I'm sure you might probably have questions also in the meantime. This law is making changes in the Companies Act. Companies Act important changes are voluntary winding up sections get deleted. Inability to pay as a ground for winding up also get deleted. Several other sections also get deleted. They get incorporated in the bankruptcy code. Likewise, in LLP Act, SURFACI Act, several other laws also. You can see lots of things are made in acts like Central Excise Act, Customs Act, etc. Why are they made? Because Central Excise law says claims of Central Excise have a first claim on the assets of the company. So this law goes and makes changes to say that except to the extent dealt with by the bankruptcy code, claims of Central Excise have a first right. In other words, all clashing priorities, the law has tried to reconcile the provisions of other central laws with the bankruptcy code. Of course, it anyway has a notwithstanding provision to say the provisions of this code will prevail over the laws of any other central law pertaining to claims on assets. Any questions? I know that. Right.
एक LLP है जिसमें 2011 से फाइलिंग नहीं करी, only for 10,000 उसके वो है contribution. Now the question is that they want to let off, but the act says they have to file all the filing, and if we go for the filing, there is a huge penalty on the LLP. So how this could help us to get rid of it?
I don't think this code helps.
So it's already, they are unable to pay the debt. The debt to the central government, they are unable to pay the debt.
Back to government. 10,000 कितनी में 50,000 फाइन में
6.5 लाख के राउंड आ रहा है.
कंपाउंडिंग तो करके फायदा सही लॉ गलत है. आप एकदम सही बोल रहे हैं, लॉ गलत है, बट आई डोंट थिंक registrar has a power to strike off.
No.
Like in Companies Act, registrar doesn't have a power to strike.
Companies Act में है लेकिन
LLP में नहीं है.
LLP में पहले पूरी फाइलिंग करिए, फिर उसके बाद कुछ काम होगा.
सही. फ्यूचर में जब होगा तो अभी तक But LLP law में ऐसे कई सारे shortcomings है, right? True. It was passed hastily without due consideration, but I think lots of gaps are left. अब जिन्होंने LLP खोल लिया सोचे नहीं कितनी परेशानी है क्या?
अभी नहीं एक्चुअली में यहाँ पे पूरा इम्प्लीमेंटेशन नहीं होता. मैं पहले से देख रहा हूँ. LLP बना दिया. इसमें इनकम टैक्स में क्या होना चाहिए, दूसरे एक्ट में क्या होना चाहिए, RBI में क्या होना चाहिए, वहाँ कुछ नहीं. उसको करने में 2 साल लगे. Can you believe 2 साल में बिल्कुल 250 बनी थी या 300. धीरे-धीरे मूवमेंट का बढ़ना.
अभी तो कंपनी से ज्यादा LLP बन रही होगी. But at the same time, for foreign owned entities, LLP is much easier because they find LLP form is lot. Now that FDI is permitted in the LLPs, LLP is much better for them. Lots of formalities of companies that are not applicable to LLPs. They find it much easier to form LLPs. Particularly good for FDI entities, but even locally also lots of companies are getting converted to LLPs.
CRC आने के बाद LLP भी बन रही है.
Right.
people are not compliant.
That's and the implications of non-compliance are far more serious under the LLP law. Correct. I don't think there is a solution. Bankruptcy court में लाके भी क्या होगा? Insolvency plan कौन बनाएगा इसको? 10,000 रुपये वाले ऐसे भी आप तो threshold limit उसके नीचे रह जाएंगे. Threshold limit will be not less than 1 lakh, but going up to 1 crore. उससे नीचे रह जाएंगे.
1 लाख बढ़ा दो 6 लाख रुपए.
So you as a professional file for non-payment of my professional fees, and as you as a सर ने सही बताया 5 लाख का बिल रेज करके प्रोफेशनल फीस का इनेबिलिटी टू पे का ग्राउंड क्रिएट कर दीजिए, फिर फाइल कर दीजिए. उसमें भी बिल द एनसीएलटी से डोंट डू फाइलिंग, बिना फाइलिंग किए आपको एग्जाम कर देंगे. तो क्या नॉट श्योर.
सर आप सरप्लस का पॉइंट बता रहे थे, तो उसमें क्या बता रहे थे मतलब कि ऐसा अगर सरप्लस आता है जो इंटरेस्ट अगर वेव ऑफ हो जाता है क्रेडिट
वो इंटरेस्ट फिर पेबल हो जाएगा. जो फ्रॉम डेट ऑफ फाइलिंग ऑफ लिक्विडेशन ऑर्डर और बैंक्रप्सी ऑर्डर जो इंटरेस्ट एक्रू करना बंद हो गया था, इवेंचुअली सरप्लस निकल जाता है, तो इंटरेस्ट विल स्टिल बिकम पेबल. Because you can't, principally you cannot pay money to an owner without paying the creditors. To the extent the creditors suffer a sacrifice, it's a like right of recompense kind of a thing. You need to recompensate the creditor to the extent they suffered due to the liquidation process. So interest will start accrue. I mean interest will be that interest which did not accrue during the bankruptcy stage will become payable if the creditors have not paid. I mean if there is a surplus. Right? Any other question? I think as Nabi Saab says, it's too late in the day to have any questions. I think it's a Saturday afternoon. But yeah, if you have any question, please feel free. Otherwise, we'll probably bring it to a happy conclusion.
But you must congratulate you, because even after lunch, you maintain the people still not sleeping. Without jokes,
मेरे ख्याल से the thought of bankruptcy keeps a lot of people awake. लोगों की रात की नींद चली जाती होगी, तो आफ्टरनून की बात कर रहे हैं.
Nice, thank you.
Pleasure, sir. Thanks a lot. Thanks everyone. Thank you.